infrastructure, I was very happy to hear Senator McKeon talk about light rail and for you to talk about the turnpike widening. Because that's one of the things that we really need to do in New Jersey. And I think that that's actually one of the aspects of the Green Amendment that would really be assisted, because there really is no law. There's not even a state plan that has teeth that will help direct our resources and our investment to places where it's not only most efficient and for the most part most resilient, but that's best for the environment. I think the positive effect will first be felt in planning. I'm a little surprised, though I don't think the word planning even came up today because we're so focused on litigation. I think it will help with forward planning by the state, the counties, even though they have a more limited role in New Jersey, and hopefully by municipalities. I think that the Green Amendment will help with environmental justice, and especially the focus, and I have seen some of it so far happen voluntarily with the Dodge Foundation and Fund for New Jersey, but I think it'll help the nonprofit sector, the charitable sector, private foundations in their distribution of aid and their focus. There's a tremendous amount of philanthropy that happens in New Jersey, not only on the corporate level, but we have a lot of very affluent individuals who, when they pass, they create a foundation, and those foundations drive policy a lot of times. They even drive legislation. So I think the Green Amendment will help focus those kind of endeavors. And I especially think that public utilities, including investor-owned utilities, as well as regional, county, and local public authorities, whether they be sewage, water, whatever they are, even municipal electric, which is mostly pass-through now, I think they really need to take a step back and figure out what they're going to do about climate change. And I think this is the kind of thing that will help them say to themselves, people in New Jersey have a right to clean air. We need to think about that now in our corporate planning and how we're going to not violate that right, but in fact advance that right. So I think there's so many things, and then you get to the darker side, which is remediation of pollution, which is progressing. That's mostly where I spend my days, but it's progressing very slowly. It's awkward, the idea of the Spill Act, writing tickets and going to municipal court. Like I have a case now that's 4 years in municipal court. That wasn't maybe such a hot idea, but nevertheless, I think I think what really is going to happen, in addition to what Maya Van Rossum said, which is, at least in the first decade, I see litigation happening as it happens anyway, and lawyers will just add this as an additional count to the complaint. So not only will there be no flood of litigation, but it's going to take a while to come into its own. Cases not only take a while to get to the Supreme Court anyway. I don't think the appellate division is going to get out very far in front on the Green Amendment. It's going to take an appropriate, worthy case for the justices to weigh in. I have a lot of confidence in the Supreme Court. I was a Supreme Court law clerk, and I think they take things in a very, very considered fashion. So I'm not worried about them being, policy advocates and all that kind of thing. And finally, it's going to function a gap-filling role, and I think that is the principal legal comment that I want to make today. I really must say I completely disagree with Alex that we have this administrative state that's efficient and effective. We do not. We have a lot of very well-considered people who work very hard to do what they have to do, but they're constrained by the fact that they only have what they have in front of them. And therefore there are gaps, and that's why there's litigation. Most litigation is because two lawyers get together, two clients, and then they hire lawyers, get together, and they have a different interpretation usually of the same exact facts, the same exact litigation, or the same exact law rather, and so on and so forth, which does not answer the question. If it answered the question, there wouldn't be litigation, it would be more clear, and therefore somebody has to decide it, and if there's not an arbitration clause, it's going to be a judge or it's going to be a private mediator or whatever. And that's why we needed that branch. I mean, it's just a necessity to have a judicial branch. But I just want to, especially because of the remediation I do, and I'm involved in a case, for instance, right now with Solvay. I'm not going to pick on Solvay, but I only bring it up because since it already has a settlement with DEP, the facts are well known. Solvay was putting hundreds of thousands of pounds of PFAS emitting into the air and water for decades, poisoning the wells of people and poisoning the Delaware River and so on and so forth. And, DEP kept criticizing their models, criticizing their air dispersion model, so on and so on and so forth. But essentially, there was no way to stop it. Or get them to, back off or, do all the things that they've done now, like substitute a different surfactant. So we need help. This is a help. It's not the be-all and end-all, but it's going to be a huge difference to say that people have this right. It's really just a complete turnaround from what we have now, which is the statutes that you all pass, which are very good, and then the administrative state. To turn around and put it in the Constitution and say, people have this right, and it's an enforceable, self-executing right. It's just a game changer.
I would like to touch upon Janine Bauer's point on Solvay and PFAS, and also a little bit of the commotion that I heard before about people suing permitted facilities. I don't think it's that. I think it's that the Clean Air Act, the Clean Water Act, and then consequently state environmental regulations are reactive in the matter of we permit pollution, how do we control it, what's an adequate level. This would provide better decision making in a proactive way. So to go back to Janine's point about Solvay and PFAS, both you and Senator Greenstein, you know better than anybody the issues that we're having with PFAS in the entire state. And we're always trying to chase the pollution because they always continuously change their chemicals. And it's because our environmental regulations are designed to only capture certain chemicals in a reactive way. This would provide a better mechanism to proactively regulate all types of pollution without having to write an entire rule about one specific chemical, which is the PFAS problem. This constitutional amendment would not only empower New Jerseyans to fight for the rights, it would actually provide them with the legal mechanism to do so. There isn't more of a fundamental right than the right to live. But how can we, if our air, water, and soil are continuously poisoned and the ability for our future generations to survive diminishes? The worst part of all of this is that we're all aware that we're poisoning our environment. We fight it, but it keeps happening. The reason it's how our systems are designed. New Jersey can never outright prohibit pollution and loss of environmental sensitive areas. We can only slow it down through permitting processes. We have been permitting environmental degradation for decades, and we sure have a lot of exemptions to make it happen. Oftentimes, environmental protection is sacrificed because of property rights. The Green Amendment will level the field, equal weight to property and environment. As a human, I have the right, my property, I have the rights of property, I have my right to live. I should also have a right to live in a healthy way, which is clean air, clean soil, clean water.
I am here to talk to you about the New York Green Amendment and briefly highlight 3 important points. The significance of placing the Green Amendment in the Bill of Rights of the Constitution, the power of the Green Amendment to fill in the gaps in existing environmental laws and regulations, and the third, the Green Amendment did not open the floodgates of litigation in our courts. What is most significant about New York's Green Amendment is the fact that it's placed in the Bill of Rights of the Constitution, which means that it recognizes environmental rights as fundamental and at the same level as other inherent rights like freedom of speech and freedom of religion. Also, just as significant, because it's in the Bill of Rights, the Green Amendment is self-executing, meaning it does not require additional legislation to be made effective or legally binding. Another important quality of the Green Amendment is that it carries force and permanency, whereas legislation is more restrictive in what it can accomplish. As a result, this leads to blind spots in environmental protection that can result in significant harm that the legislation did not anticipate. And we heard from prior testimony about these legal gaps or blind spots. And I can offer two specific clear examples in New York in environmental justice communities in which these blind spots were present, which means that the system was broken. One is the village of Hoosick Falls in Rensselaer County. For many years, the residents have been unknowingly drinking water that was contaminated with PFAS, which, as it's common knowledge, are highly toxic chemicals. But because the population was roughly 6,900, the village was not required to test their water system under the regulations as they existed in 2013. Those regulations were triggered for water systems serving more than 10,000 people. So the contaminated water went monitored to the health detriment of these residents. And they suffer from severe illnesses, including kidney cancer, testicular cancer, and colitis, because the right to clean water was not protected. And I represent here today that the right to clean water should not be triggered by a numerical threshold in population. Every single person has the right to have clean water. Another example of this legal loophole is the South Bronx, specifically areas like Hunts Point and Mud Haven, which are sadly referred to as Asthma Alley. Because these communities have been saturated with toxic emissions from picker plants and other polluting industry infrastructure that emit carbon dioxide and nitrogen oxide in increased amounts, the existing environmental laws were not sufficient to protect the residents' right to clean air. And it is common knowledge that the South Bronx has one of the highest death and disease rates from asthma in the country. And this is precisely the type of situations in which a Green Amendment has the power to bridge those legal gaps and offer protections to address the unanticipated and unaddressed consequences to ensure that all people have the right to clean air, clean water, and a healthful environment. Lastly, as I mentioned earlier, the enactment of the Green Amendment in New York has not led to vast amounts of litigation. In the past year or so, 2 years that it's been, since it has been enacted, only a handful of cases have been filed. And only those with meritorious claims alleging significant harms of serious community concern have advanced. Two quick examples. The Fresh Air for the East Side was the first case that was filed in New York on behalf of residents of Monroe County living near a large solid waste landfill. The fugitive greenhouse gases and pollutants from the landfill, including methane and sulfur compounds, have been severely harming the community since 2017. Another case in point is an action on behalf of the residents in Albany County against the Norlight Waste Incineration Facility, because the emissions have caused severe air pollution by releasing crystalline silica and dangerous levels of particulate matter. In both these cases, the long-term exposure to the dangerous air pollution has caused severe adverse health consequences, including lung damage, cardiac disorders, aggravating asthma, and increased rate of mortality. And this is the reason why these cases have advanced. I can represent to you that if a case were brought because someone doesn't like the sound of the windmill, that case will not stand. It simply will not pass muster. The objective is for the Green Amendment to protect environmental rights and to inform how the other laws that are at play should be interpreted and applied. So these precedents should deter litigation if the laws and regulations foster a clean and healthy environment, and those considerations lead to protecting the constitutional rights.